How to create a valid will, what law school doesn't tell you, but probably should. 1. The myth of complexity. There's a long-standing belief that writing a will is some sacred legal ritual, reserved for mahogany offices, hourly billing, and embossed stationery. But as Paul Rabelais, a 30-year estate attorney, explains, sometimes it's just paper, ink, and a few keywords. So what does that actually mean? It means in some states, like Louisiana, a handwritten or holographic will is just as valid as one produced by a high-priced law firm, provided the formalities are followed, dated, handwritten, and signed by the testator. Footnote: holographic wills are recognized in several U.S. states if they meet specific legal formalities, date, handwriting, and signature by the testator. 2. The scenario: one family, one page. The example is deliberately simple. A husband, let's call him William Willrider, wants to leave everything to his wife, Wilma. If she dies first, everything goes equally to their 2 adult children. No trusts, no lawyers, no Latin. Within minutes, a valid will emerges on plain printer paper. I, William Willrider, declare this to be my last will and testament. I revoke all prior wills and codicils. I leave all my property to my wife, Wilma Willrider. If she predeceases me, I leave my estate in equal shares to my children, William Willrider Jr. and Wilhelmina Willrider. If a child predeceases me, that child's share shall pass to his or her descendants. I name Wilma as executor. If she cannot serve, Wilhelmina shall act without bond. And that's it, signed, dated, done. So what does that actually mean? It means that for a straightforward estate, a valid will may be less about ceremony and more about clarity. Footnote: a properly executed handwritten will containing clear intent, revocation, and distribution clauses is legally sufficient in states recognizing holographic wills. 3. The power of simplicity, and its limits. The exercise demonstrates that, under the right conditions, estate planning doesn't have to be intimidating or expensive. Yet, as Rabelais notes, simplicity has its limits. Complex situations, minor children, special needs dependents, tax issues, second marriages, business ownership, need more than a sheet of printer paper. So what does that actually mean? It means quick isn't the same as complete. A one-page will works only when the life behind it is equally simple. Footnote: holographic wills serve basic family scenarios but may fail in cases involving minors, blended families, or asset protection concerns. 4. The real lesson: understanding over outsourcing. Many people delay estate planning out of fear of costs, legal jargon, or the process itself. This demonstration is less about do-it-yourself law and more about reclaiming confidence. Knowing what a will does makes it easier to know when you need professional help. So what does that actually mean? It means empowerment comes from understanding, not delegation. Footnote: basic legal literacy in estate planning helps individuals evaluate when professional services are necessary and when they are optional. 5. Toward accessible estate planning, the bigger idea. Rabelais ends with a provocative question: what if there were an online platform that provided forms, instructions, and videos for simple scenarios, so families could create legally valid wills without the 4-figure legal bill? In other words, democratizing estate planning. Not replacing attorneys, but making them optional for those whose needs are modest. So what does that actually mean? It means technology could make peace of mind affordable. Footnote: accessible digital estate planning platforms can reduce barriers to basic legal protection while maintaining compliance with state law.